So the second task is the most pleasant, and that is to thank all of you for coming, and especially to thank my colleagues, Herschella Conyers and Michelle Geller, for putting together this program and these panels. And then the third task is the obvious one, which is to comment a little bit. Don't worry, under 3 minutes, I think I was told. Comment a little bit on the excitement of anniversaries, and in particular of the excitement of an anniversary that thinks about the bringing of clinical legal education to the University of Chicago and its growth and its future. And it's too easy in a room of believers, so I will just describe what it's like to have been a non-believer, which is when I was in law school, I was not smart enough or lucky enough to take any clinical courses. I'm not really sure I took any academic courses either, but that's a different subject. And then I sort of went on in life and did a little work and became an academic and always noticed that there were clinics nearby but never had anything to do with them. And then even after I came to Chicago, it was not until I became dean of the law school that I really began to focus on, well, what is it that our clinic and other clinics do, and what is it that we could do, and when we expand, as I think we have and should do every couple of years, and try to bring different kinds of clinical legal education to more people, how would we do that other than just copying what other people do? You sort of go out and you try to talk to people who have some experience, people who have been to the law school, who are out in the world and who remember their clinical experiences. And self-critical as it is, if I meet people that I taught corporate tax to or corporations or some other course 10 years ago, they usually, as all teachers know, they usually remember the most trivial things about your class. Oh yeah, I remember the day you explained to us how to multiply everything by 11, or something like that, and you just want to bang your head against the wall and think, it would be nice if they at least remembered some legal theory or something. But almost invariably, everybody remembers their clinical legal education. Everywhere you go in the country, almost the more distant people are from their clinical roots, the more they say, you know, I really learned a lot in law school, but the place where I learned the most and got the most attention and where things really stuck with me and made me a better lawyer and a better citizen was in the Mandel Legal Aid Clinic. You know, and at first, that's sort of a chilling thing to hear, where chilling is not necessarily good, because you think, you know, what about me? You know, but after a while, you come to think, this is really the most fantastic thing an ambassador can hear when you go around the country. That people remember what they learned and how they learned it, and that even as they're doing that, there are actually other real people who are, that is clients, who are beneficiaries of the clinic, perhaps not as important to me as it is to other people, but you know, that's, as far as I'm concerned, sort of a nice little side effect. And so on behalf of all those people out there in many, many countries and many cities who couldn't be here today, but who are grateful for the 50 years of clinical legal education they received here, much of it at the hands of people who are sitting here today. I thank all of you who are involved in clinical legal education, and I'm grateful for the fact that you're constantly reinventing yourselves and thinking about how what you do can be done better and how the next 50 years can be even better than the first. So thank you very much, and I hope today goes well.
I would like to introduce our moderator for panel 1, Jeff Leslie. Jeff Leslie is a clinical professor. He does our housing project. Jeff has been with us 5 years? It seemed only like 2.5, but okay. Jeff's been with us for 5 years, and he is going to moderate our first panel. Jeff?
Very good. Thanks, Herschella. So our first panel, our topic is Signature and Shadow Pedagogies, Coexistence or Collaboration. As you probably noticed, and looking at the bios, we've had a couple of lineup changes. I'm filling in for Beth Milnickel, who couldn't be here this morning, and Peggy Cooper Davis got caught up in an ice storm on the East Coast, and Mark Hireman is filling in for her, and we're grateful that he's doing that. Our format for this panel is going to be to have each presenter talk for 15 or 20 minutes, and then we'll have some discussion and opportunity for questions from the crowd. Just very briefly, let me tell you a bit about each of our speakers. We have Judith Welch-Wegner, who will go first. She's been a leader in thinking about and writing about pedagogy in law and the professions. Randy Picker, who's widely regarded as one of the law school's most effective classroom teachers on the academic side. and Mark Hireman, who's an experienced clinical teacher here and has been a leader in the clinical legal education movement. You can read more about them in the bios. So with that, I will turn it over to Judith to kick us off.
Thank you. It's really an honor to be here at your celebration for your 50th year of your clinic. I have to confess I'm a beginning clinical teacher in a sense. I decided this year that I wanted to be second chair to one of my pre-tenure colleagues in our community development clinic, in large part because of the research I've been doing with the Carnegie Foundation and beyond that. So I can safely say that I come to learn as well as to try to share some of what I've gathered in the last decade. I'd like to just ask, in order to get to know you a bit, how many of you are currently students here? Thank you for coming on a Saturday morning. And how many of you graduated in the last 10 years and took clinical courses? And how many took clinical courses prior to that? And how many are in legal aid or similar kinds of work now? And how many are in corporate practice or things like that now? And everybody else, it's good to see you too. So thank you. That's the warm up. Well, I want to do a couple of things here. First, I want to give you a little background about this Carnegie project in order to lead into the notion of signature pedagogies. Then I'll say a bit about what that phrase may mean and how it might be helpful to our conversation today. I want to say a bit about the case dialogue method, which is generally thought of as a signature pedagogy for legal education, and then leave you with some questions and challenges for further conversation. The Carnegie Foundation for the Advancement of Teaching is about 100 years old at this point. For the academics in the group, one of the claims to fame for the Carnegie Foundation is that it helped spur the creation of TIA-CREF, which is something that many of us look forward to enjoying at some point down the road. But at the early part of their development, they did a series of studies on different types of professional education, the most well-known of which is the Flexner Report that studied medical education and really helped contribute to moving medical education more into the academy. What I think the Carnegie Foundation has done under the leadership of Lee Shulman, who's a distinguished graduate of the University of Chicago, not law school, but his PhD in psychology was here, is to really look at professions again in honor of their centennial. As you're having your 50th anniversary, you may think about what it was like at the start and where you've gone now. They wanted to find out really what is happening with professional education, but to do it in a somewhat different way than had been done back at the outset. And the way in which we have gone about doing that was to really focus on teaching and learning with a very concentrated focus. There's many a thing one could study or consider with regard to any of these forms of professional education, but to really think about teaching and learning and to take a comparative look by picking up on what's happening in education for clergy, engineering, law, nursing, and medicine, so that you could see some trend lines or gaps or comparisons across those different fields, which turns out to be really quite illuminating. And in addition, to try to take as a premise, which may well be a contested premise, and I would think perhaps contested within these halls, so we may hear more about that, namely that for professional education, it's at least conceivable that there might be some attention to what it is to be a profession once students have finished their education and go out to the world of the profession. What we worked with as characteristics of professions that might well be touchstones for different fields of professional education were the following things. One dimension, the development of fundamental knowledge and intellectual capacity, which for me, the more I've thought about it, and I've thought about it a lot, for us in legal education is really to a large degree about epistemology, about, for those of you who are philosophers, theory of knowledge. And those of you who are economists, I found in the work there with Carnegie, talking to historians and political scientists and others, they were absolutely entranced when I would talk about thinking like a lawyer and the need to try to understand what was that about as we did our field work. So they began to talk about what it meant to think like a physicist, what it meant to think like a historian. But that's something I want to come back to in a minute. Also, the fact that professionals have to make decisions under conditions of uncertainty, which again I think is of critical importance. So oftentimes, I know in the clinical world, that's something well appreciated. I'm not sure whether those of us who do stand-up kind of teaching in other respects have thought so much about putting that explicitly on the table. In addition, the capacity to engage in complex practice and to learn from experience, an ability to create and participate in responsible professional communities. I think for us, we often act in law school, apart from some settings like law review or clinical settings, as if people are solo actors. But the fact of the matter is, for professions, they function as communities. That's what licensure and malpractice and things like that are about. And then finally, as I know you know, the classic expectation of someone in a profession is to give service to the public. So we use those framing dimensions as something, as we worked on the different fields we took in common and thought about whether, as we observed, in my case, legal education, and as others worked on clergy and engineering and all, what were the ways in which those different fields address these framing dimensions. What was used really as metaphorical ways of articulating and making visible dimensions of the teaching and learning process across these different fields were a couple of things, only three of which I want to highlight here. One was the metaphor of apprenticeship, not in the sense of the old-time apprenticeship, Abe Lincoln turning pages in the dark to work with someone in their office and gain what could be gained about the nature of law, but rather as metaphors. There's been a great deal of interesting work done. Some of you, no doubt, have had experience in sociology and possibly education, things of that sort. There's a notion that has grown from understandings about how expertise is developed, which is called cognitive apprenticeship, meaning that's really an apprenticeship in which one learns about thinking and analysis and things of that sort. John Seely Brown, who has been involved with computer science and things like that, is someone who really has used that term and really delved into that with great benefit. That's something I think, as I'll say in a minute, we do very well. The folks on these field site visits with me, none of the rest of them being lawyers, were frankly blown away by how effectively in the first year, particularly because we were sitting in on first year courses, legal ethics courses, clinical and legal writing and things like that, but how effectively we were able within legal education to work on that. But as the framing metaphor goes on, it's not just about thinking, it's also about doing, if you're thinking about what professionals are involved in. And so comes the second metaphoric apprenticeship, one of skills and practice, how you actually do things that need to be done. And then a third dimension, an apprenticeship of identity and purpose, identity and values, which I think is frankly our weakest suit within legal education. The clergy study, the title of which is Educating Clergy, is out there, and some of you may find that of interest. I had not been familiar with the metaphor used in that arena of formation, in the sense of uniting these three dimensions of someone's growth into a professional role. And that sense of formation, how all pieces come together, is part of how we might think about the development of students who are becoming legal professionals. I don't think we're very good at putting those things together or seeing that as a shared responsibility or opportunity. So that's one of the concepts, apprenticeship, in this multiple dimension. The next thing really is about the learning sciences as they have developed. There's an excellent book called How People Learn, done for the National Academies of Science by John Bransford and others in around 2000. It's available online if you are interested in that through the National Academies Press. There's a great deal that has been learned about how people learn. Particularly relevant to us is the development of expertise, going from beginner, advanced beginner, intermediate, think of swimming lessons, think of becoming a chess master or a master violinist or something, you get the basic idea. But the appreciation that when we are at this stage working with students on their way to becoming a professional, we really are moving them, helping them move from being novices on up to higher levels of expertise. How does one become an expert? Well, I use homely examples such as learning to bake bread from my grandmother or learning to fix a car. You can pick things for yourself. Learning to ride a bicycle. You don't do that out of a book only, right? Probably not much out of a book. You have to really observe the whole picture. Before you could ride a bicycle, you'd have to see somebody else go down a hill on one, wouldn't you? And then you'd have to come back and learn which way the pedals go and if it's got hand controls and things of that sort. Well, through a great deal of study across all different fields, midwives, tailors, chess masters, pilots, all the rest of it, it's really clear that what expertise is about and what one does in moving from novice to expert is to encounter a variety of scenarios and become really so grounded in scenarios that you don't really have to go back through your rule book to figure which one applies. You just become much more masterful at appreciating tacitly what's going on. And I think that you all in your own life, be it your son's soccer play or whatever it may be, would find that worthwhile. But that's a very powerful insight, I think, because often we as scholars, faculty members, we are experts, right? How did we become who we are? Well, some of us did PhDs and learned expertise of how you take on a problem and work with it systematically through a mentor who's our supervisor. Others of us who've been through clinic program, you see what I mean about multiple twists and turns and scenarios that gradually get you where you're going. But that's a second major insight, I think, from Carnegie that's really worth further reflection. Now to the subject of the moment, which is this notion of signature pedagogies. Lee Shulman, the president of the foundation, who's finishing his term this summer, brilliant man, absolutely brilliant. He has worked in psychology, in medical education, and in teacher education for many years. So I think in his soul, he's been in search of what could be a signature pedagogy to help teachers be good teachers for K-12, among other things. But he has worked with reinventing medical education using problem-based teaching, and he's been a Talmud scholar for many years too, so he's deeply thoughtful man. He and the rest of us coming in and out through this 10 years of Carnegie work really, I think, have come to believe that there is such a thing as a signature pedagogy or more than one for each of the professional fields. The point of a signature pedagogy, according to Lee, which I think is true, is it's something distinctive as to each of these professional arenas. It's something that is pretty widespread within each of the institutions in like a college or school, and it's widely accepted across a lot of schools, across institutions. What is the power of that? However, I think that is really what is important to put before you today. It's distinctive, it resonates with the identity of the profession. It's powerfully effective, and it's effective for a lot of reasons. Lee's written about, for example, while they did the field work for medical education, sitting in on rounds and seeing how rounds progress and what the students' role in that and what the residents' role and the professor's role would be. But that there's some understanding about the rules of engagement that go with that pedagogy, that it's fundamentally bringing to the surface and making visible thought processes that might otherwise go unexamined. It's a situation where students are accountable, that they can't hide out and be silent. Lee has suggested perhaps that when you think about higher ed generally, the use of clickers that some people have gotten into to try to get students to give back, engage, if you have a class of 400 people, may become something in a sense by which that form of education is enhanced as people engage with the students and hold them accountable. And it's also a setting where students are vulnerable, where, as Lee would say, they may have pure straight terror, but they learn to master that to get to a point of tension that it is a fruitful tension. I talk to my students about, in the first year, the need to appreciate that we're dealing with uncertainty and that part of what they have to do is domesticate doubt, that they have to somehow recognize that it's like my beloved cats or your beloved dogs or fish or birds. Somehow it's going to be a friend to you. It's still wild and a little bit crazy, at least my cat is that way, but it's somehow something that's part of us and we're comfortable with dealing with it. So that is kind of generally what we're talking about when we talk about signature pedagogies. And for medicine and nursing, it would be bedside teaching rounds, clinical care. For engineering, it would be design studios, things of that sort. For us, I think classically it's the case dialogue method, and it's incredibly powerful. I did visits to 16 schools across the U.S., 2 of which also were in Canada, watching first-year classes. It's practiced differently, but you all know what I mean. It's putting forth a case, having dialogue between the class members and the professor, so you're bringing to visibility what the thinking is. You're probing people, you're pushing them to a point where they're really going to have to be thinking on their feet. And as they get more masterful, then you let them fly. You can kind of fall back and not have to give them as much support. It really was, I think, created by Mandel back in the day as a means of saying there should be value added to being in class, not just reading books yourself. And it should really be something that engages people in, as I was saying, this kind of collaborative enterprise that should be characteristic of professions. It also has the benefit of helping students develop what we call legal literacy, namely capacity to read in a textual universe that's different from anything they've seen before, and to appreciate some rudiments of the legal landscape. And it's got really remarkable analytical moves. Lee Schulman studied with Benjamin Bloom here at the University of Chicago. And as I think many of you may know, Bloom developed a taxonomy of educational objectives based on comprehensive exams that were given at the end of bachelor's degrees here and at other elite schools at the time he was working. So what that set of objectives included, not only knowledge, but comprehension, analysis, application, synthesis, and evaluation. Any given day, that's what we're doing. So in a sense, by the very intensive approach we have, and by virtue of the students we're lucky to have, we're able to kind of work our way into building that capacity. But there are critiques that are warranted critiques. I think sometimes because we're doing it in large groups, we may leave some people behind. And it's a narrow way of defining what analytical approaches may be. So you here have incorporated things like economics and all as you proceed. I think there's still intellectual gaps that are left on the side. I think it becomes less engaging as time goes by, and if it's a dialogue and people aren't really jumping into the dialogue, it hits the wall sometimes. It also isn't particularly good at addressing the other 2 apprenticeships. Very good at cognitive, not great at skills, very much not great as to identity and values, because the materials you're working with, the pedagogical moves you're making, and oftentimes the professors who are teaching have not got that sense of the profession in a rich enough way that would allow them to complement it. And it, as Peggy Davis would say, and I want to just briefly highlight what she would have said if she was here, she would say that there are problems with it because it is biased, or it furthers hierarchy in a couple of respects. One is that, as her colleague, or I think, no, he's at Harvard. I think he's done work with Peggy, but Howard Gardner, some of you may know his work about multiple intelligences. Peggy has said that if you think about it, case dialogue method is good at analytical, kind of quasi-mathematical reasoning, not very good at psychological, or pretty good at linguistic, but there's gaps in what kinds of intelligences it fosters, and as a result, you leave some things out. She would also say that it segregates because it deals with certain things, but it doesn't deal with things like fact development or persuasion or other dimensions that really come in clinical education. And she would say that it tracks people because some people, well, it isn't just the method. I think our grading systems are such that you end up doing fine distinctions among people depending on how they play out this expertise in analytical problem solving, that if you really step back and look at it, that's baloney, because I do believe it's really beginners, advanced beginners, intermediates, and I've taken to every exam I give or paper I have people write, I tell them where they are on my expertise scale, and I put it right there in front of them. Much more helpful for them to get an idea about where they're at than trying to just say, let me compare you with a summer's day or your neighbor to the left or right. So there are flaws, and it may well be that others here will bring those out, but what I think as I close here I want to put before you is the question, given that if you agree with me that that is indeed, that we have a signature pedagogy, which is more or less the case dialogue method, however varied from one place to another, are there ways for those of us like the next speaker who teach stand-up courses that you may be able to integrate and bolster these other dimensions, these other apprenticeships in terms of skills of different types and sense of professional identity and values? For those of you involved in the clinic universe, are there signature pedagogies that you have that those of us who aren't living in your universe might learn from? I say that also to legal writing people because I think in a lot of ways they are the ones who fill out the individual learning that large class case dialogue doesn't really handle, as well as doing other things with literacy and capacity to write. But are there things you have? I've read a recent, and I commend you, very good article by Elliot Milstein and Susan Carpenter, who wrote about rounds in the clinical setting as a signature pedagogy that, in a way that's very illuminating and very engaging, and I think would be very worth reading to any of us, whatever our backgrounds. So are there other signature pedagogies? And then finally, how do we engage across our different experiences? Because as your fine dean said, some of us did not have the benefit of clinical experience while we were in school. Some of us think that what we're doing, be it antitrust or whatever, state, local government for me, or whatever it may be, has so much going for it that there's no time to get to these other things that people might pick up as they go. One thing I believe, and I've in my own writing on legal ed, I think I've demonstrated to myself, if you go back to the Greeks and think about the different nature of knowledge, the different forms of knowledge, the theory, the building of art or construction of art, things like that, or performance, and then finally praxis where you're dealing with situations of uncertainty where judgment has to be brought to bear. I think that's what faculty do when we do scholarship. I think that's what clinical people do every day. I think that's what happens in advanced seminars in whatever the subject is, and I think we have more in common than we've given ourselves credit for. So with no further ado, I will quiet down now and learn from our colleague who says we can sit down so we can see his slides.
Exactly. So I'm going to get up and walk around.
Very good, thanks. Thank you, Judith.
So, Judith didn't plug the book. I'll plug the book for her. It's Educating Lawyers. It's on Amazon. I've read part of it, not the whole thing, and I think it's definitely worth reading. Definitely worth spending part of your research on that research, right? So, I've got that in mind. I am, as it were, I teach in the final curriculum, I guess, is the first good. Let's see, did I get that right? Did I get that right? Yeah, exactly. Well, I teach in this room. I guess is a country doctor. It's a novel about what it was like to be actually a woman doctor in New England in the late 19th century, right? Confronting all the problems associated with treating patients. I think, you know, in some sense, the scale of her job, if we moved her to the Mayo Clinic, in some ways doesn't change very much. There's a human being in front of her, that becomes some interaction. In contrast, I want to say the law business is a business of continuous scale. So at one end of that, maybe the most common legal transaction is the will. I don't know, right? Maybe it's the apartment lease, the mortgage. Those are seemingly in the news a lot these days, right? I don't know. Maybe that's the most basic transaction. But those transactions don't necessarily look like much of transactions other than right? So I teach antitrust. You mentioned it's hard not to spend a lot of time talking about legal in this context. The kinds of legal problems they deal with, or the sources that they bring to bear on them, right? The kinds of analyses they do are not nearly, right, sort of the will margin, right? I think they're almost different. So I think there's a question as to, if you said, okay, we want to try to organize around the singular experience of what a lawyer is, I think it's much easier to do that in medical school, this idea of the variance scale. I think it's actually much harder to do it in a law school, where actually the unit of analysis in one course might be very different than the unit of analysis, the large preparation, in another course. You know, I can imagine setting up a legal will study, right? I can easily do that. I think that would be successful if the students would draft wills, you would find clients who wanted wills drafted, they would come in. I think you could do that. We set up a Fortune 500 antitrust firm. I'm not sure how successful that would be. My guess is most of the Fortune 500 wouldn't rush to it. Say, you know, we've got really able students. I love our students. I know the students here. I will say the same ones here. They're smart, okay? Can't answer anything other than that. Notwithstanding that, they're new. They're learning, right? And so if we set up a Fortune 500 legal clinic designed by antitrust services, the top firms in the world, I don't think they're coming. They want people with more developed expertise. They want people, you know, 12 of you or 20 of you, right? You have a school with 1 or 2 antitrust professors, a lot. These men take enormous amounts of expertise. It doesn't scale up very well. And so I think there are, the Carnegie report talks about an integrated model, right? I think there are some situations where integration, that is the meshing of clinics and skills and substance, is easier than in others. And I think this one size doesn't fit all idea means that you need to sort of try to be much more contextual about what works in what areas and what might not work in other areas. All right. The other thing that I thought was interesting in the report, and it talks about it a little bit, boy, it doesn't say much about it in the report, is the report is called Educating Lawyers, and it doesn't focus on the research side at all. So what I think we do at the University of Chicago, here at the law school, the rest of the university, is we do education and research. We create ideas and convey ideas and teach students. That's what I think we do. And so when you think about what we do at the university, what we do at the law school, very hard to talk about that and think about it without having a pretty firm sense of all of the research that takes place at the University of Chicago Law School. These are just the journals published at the law school, right? These aren't the books that are written, these aren't the papers that are published elsewhere. This is all done together. At the same time that I hope we're producing a great education. And the report says almost nothing about research. I gotta say, I found it very odd. You know, it's like if we went to IHOP, International House of Pancakes, we said, you know, this pancake thing, we know it's important to you. We're going to focus on omelets for a while. We're going to teach you how to make the best omelets. We're going to figure out how to redesign business practices to make the best omelets. But we're not going to think about the interaction between omelet making and pancake making. Maybe actually, if you're relationship between education and research. I'll start with the study report on that. Right? The Carnegie report is one of the most visible reports, the study report on best practices development. Boy, you go to where you start, know your subjects extremely well. Say it goes without saying. Okay. But I want to say what that really means. I think that, the proof and evidence, I got my hands full of that. But let's talk about what that means. So I want to talk a little bit about how I use antitrust here. So I taught antitrust in this room in the fall, 135 students. So obviously one of the things that everyone recognizes about how you design education is the cost issue. You've got to figure out how to do it. But obviously one of the things that the case dialogue method does reasonably well is it scales up. We can put as many people in the room as it will hold, and it will hold 135. Let's talk about what we actually do in the course. I'm bringing up my syllabus, which I put up on the first day of class. It's on the web. We can flip through that. I don't actually use a book, so all of the materials are downloadable. We start with one of the great early cases, the Trans-Missouri case. The joy, the curse of not having a book is that you can obviously update your materials as rapidly as you want to, as rapidly as you need to. So the latest and greatest on mergers is the Whole Foods Wild Oats merger, which was in the middle of 2007. That's not in case books. It's not in supplemental materials. You obviously have to do that yourself. The latest and greatest from Europe is obviously the Microsoft case. That case came out on September 17th. We started classes on roughly September 28th. That decision was roughly 300 pages. I guess it's not down to 40. We live in a rural market. I don't want to say committed educational malpractice because they don't have insurance, so I'll be careful. But I think it would have been a mistake not to teach this case. There's a lot involved in doing that. Okay, so most of the materials I'm using. The other thing I'm doing, though, that might not be obvious, well, that's interesting, is I use PowerPoint slides in class every day. And what I want to go to is what I think the content is. It's interesting that the Carnegie report only looked at first-year classes. I think those were very different in many ways from second and third-year classes. The antitrust class is obviously a class where economics, in some sense, at the core of the class. The students need to come out. I tell them coming in that they don't have to know any economics at all. Don't expect that at all. My mission, if I choose to accept it, is to make sure they understand reading. They don't have to know any coming in. So I have to build up demand curves from raw primitives. I have to explain why monopolies are bad, which is the deadweight loss triangle of monopoly, right? I have to explain how we think production should take place, how production is organized, how production scale affects, right? What the competitive opportunities are, where we think we're going to see monopolies, where we think we're not. We're through day 2 of the course at this point, right? Yeah, exactly. When you teach a class like this, it's incredibly important to understand active business practices. So one of the leading antitrust cases is the broadcast music case. You really can't understand that case unless you understand the old country effect. It's important to understand all-you-can-eat situations, the difference in all-you-can-eat situations when you're dealing with physical goods. I guess that's how people deal with music effect. Versus intellectual property goods, which is songs and patent rights and the like. That's what broadcast music is. All of that has to, in some sense, be done. It's not as if the students will, in some sense, have that coming in, and you can't really understand what's at stake in the case until you actually work your way through that. We then turn to sort of market definition, cross-elasticities of demand. Where do I get this? I get this out of a 1954 Supreme Court case, DuPont. This is exactly the framework they developed. My students don't understand that. I have to develop that for them. I need to give them a sense of how substitution and complements work, because you can't really understand market definition without all of that. None of this is really laid out in the cases, right? And we sort of have to do all that. We have to do all that day by day by day. Look at this. This is interesting, right? One of the things that's obviously changed is the easy availability of other materials. So you can actually, you don't have to look at the cases necessarily. You can look at the complaints. So the quality cases in the Supreme Court, you've got a paper coming out of the Supreme Court review. You know, the real issue is how the complaints are. Right. Let's look at the complaint. That, you know, it's very important to look at other materials that lawyers actually work with. So we can do that relatively easily here in this context. It's a very natural thing to do. But it also means that I think that there's a little more integration going on than you might think otherwise. And we can go on and on and on and on. More economics. I guess I've made my point, right? I mean, I guess that's all I want to do. So I want to say that I think the things that need to be done in a modern law school course are actually quite substantial. I don't know if there's a unique thing right now. I'm teaching a course right now that's called Network Industries. And it's a harder course than enterprise. That's the hardest course I teach. It's got both law, economics, it's got knowledge overlay, which we're going to understand how electricity transmission really works, understand how we're going to regulate it. So I think it's a harder course. We'll be copyright infringement and easier course because the biggest statutes that we have to master. But what I want to say, I think, is that I think that there is a, you know, powerful set of demands that goes on in this kind of course. It's not obvious to me how much trying to integrate additional practice materials into how to fit. Do we look at things other than cases? Absolutely. We look at complaints. In my network industries class, we're looking at a case that is pending in the Supreme Court. We pulled down the briefs. There are a zillion briefs. The ABA does a great job of putting those briefs. You can look through those. Get a sense of how people are framing the arguments differently depending upon the position. See what the amici are doing. Very, very interesting to see. All of those materials are available. I mean, you do a certain amount of statistics in these courses. And then the question is, and now I circle back to the Stuckey report, is to say, well, what does that mean for me, other than having had to have learned an enormous amount of PowerPoint? Well, I guess that's where I want to go. So work my way back. You know, what does that mean for me, I think, is the question. And how does that then relate to this idea of, well, you're supposed to know your subject well. I think that it's extremely difficult to separate knowing your subject well from doing research. I think that, and we'll take that in pieces. I think that means you at least need to consume research, right? So it's hard to understand the bundling that is going on in the Microsoft case, where Internet Explorer is being bundled into Windows, or where Microsoft at one point puts together the Microsoft Office with Excel and Windows, PowerPoint, and other things. I think it's very hard to understand that without understanding what that research looks like. I won't pull this paper up. This paper's got a billion equations in it. That's because that's what modern economics research looks like. And that's because, and Barry Nailbuff is not some wacko. Barry Nailbuff is the guy testifying in these cases. The guy our students are going to be either deposing or using, working with, 5 years from now. And I think my job is to get them to all of that. I'll say one more thing and then I'll stop. I also want to talk about, the way in which students can interact through technology, as it were, and the way in which that changes the kind of education we can do. I teach a seminar on antitrust and intellectual property policy. We read a variety of secondary literature papers there. First day of the class, we read a paper on welfare economics by Ken Heyer, who's in the Department of Justice, antitrust division. What we do in that class is I have students, I divide them up into groups, and they are assigned writing windows in which they have to write comments, let's hope this comes up, comments on, coming up, the class blog. So we use a blog in the class, students are assigned slots to write in. They post things on the blog. These are like 1,500 word papers they write about the paper. They are divided up into groups. Group 1 posts at this point, Group 2 posts at this point, Group 3 posts at this point. They then are required to put up comments to have an online discussion, and then we bring that into the classroom. So that takes place over a week or 2-week period. We then come to class on a Thursday, and we then talk that through. The other thing you get when you do that is not only does this discussion take place in our classroom, but this discussion also takes place across the web. So we get this very extensive comment from Ken Hyle, the author of the paper. We let him know we were having this discussion. He says, boy, I've been reading, here's what I think. What he says nicely is, I'd love to hire you, good, I'm happy to hear that. I hope our students are attracted to the market. But that's, I think, where we are, and partially that's been driven by, a set of tools that I think make this possible. All of that enriches the discussion in, I think, a powerful way. And so I think it's actually a great moment in teaching, but I think it's also a lot of responsibility, and I think there's a lot going on there. As we think about integration, I have a question as to how much of that we can do in particular courses, how much of that needs to rise up organically in particular situations. And I do think it's really important to understand, I think, the full set of obligations that I think the Stuckey report, imposes, insists upon correctly, which is what it means to know the subject well, and whether you can simply consume research to know the subject well, I don't know. There's no doubt in my mind the things I understand best are the things I write. No doubt whatsoever. Talk about values, and I'll stop. I think one of the things, as I heard Judith talk about that, I'm so naive, I'll just admit to it. I think what we do in law school, I think what we do in my classroom, I think what I do in research, I look for understanding. One of the things when I came into this business is I hate to not understand stuff. I think that's really frustrating. So I want to understand. And I think that's just looking for truth. It can't be a good thing. It can't be a bad thing to sit around all day and talk about how you figure things out and to try to understand if you ask me what we do at Chicago, I know what I think we do here. I can't speak for any other school. What I think we do here, I hope this is what we do. Great research. Students who are going to become great lawyers. But we prepare them to become great lawyers. Not that we made them into great lawyers. I think we're much more, my second school, right? Not Yale. We actually people on here, right? Not everyone's going to be a solo practitioner. I think we're going to have clerks. We're going to have judges. We're going to have leading lawyers. I hope that's what we prepare them to do. Thank you very much. Turn the lights back on and turn this off. I'll take care of that.
Well, thank you, Randy. Mark, I think when you're ready, I'll keep it away.
Good morning. So I'm not Peggy Cooper Davis, and I was pressed into service yesterday, and I have probably a different approach than she would have taken. For that, I apologize. It seems to me that if we're thinking about pedagogies, whether we're thinking about law school pedagogies or any other pedagogy, it's useful to think about what the goals of the pedagogy would be, as I think Randy Picker talked a little bit about. And it's useful to think a little bit about how we had the clinical education movement, and I think it's useful to at least a little bit understand that it is a movement, and what were the goals of this movement. Talk a little bit about that. I think the goals were incredibly ambitious, contradictory, and perhaps a little bit diffuse. But I think it's important to at least think about what they might have been, what they are going forward. I think fairly obviously one of the goals of the clinical education movement was to reform legal education. But way beyond that, reform the practice of law, reform the law itself, and reform human interactions. Indeed, I went to a clinical conference in which, led by people from the psychotherapeutic movement, we spent the entire 4-day period talking about human interactions from a psychiatric perspective. Whether or not that was a useful investment of our time, I'm still not sure. But in fact, a law is a lot about human interaction, so it wasn't irrelevant. With these very, broad and unachievable goals, but I think important goals, it's then useful to think about why, at least some of these goals, and think about why we would have these goals. And I take it that the idea behind at least goal A and goal B, reforming legal education, reforming the practice of the law, is based upon an assumption, which perhaps not everyone subscribes to, that the results are not very good, that the practice of law is not very good, that the quality of lawyering in this country, or perhaps other places where our graduates may go, is not very good. And part of the problem with that assumption is it's very difficult to prove it one way or the other. And I think people perhaps in this room have different views about whether this assumption has any merit at all, and how we would know whether it had any merit. So for example, just to compare this to some other areas of education where we have spent a lot of energy, the Congress passed a No Child Left Behind law, which people can either like or dislike, but it was based upon a generalized agreement that our education system had at least two big problems. One, it wasn't as good as talking about primary and secondary education, wasn't as good as other countries that we may need to compete with in the world in terms of results, and that there were huge disparities in the results in the United States across the country, between states, between communities. And the data for those assumptions were testing. Our students don't test as well as students in other countries. Our students in community A don't test as well as students in community B, and we would like to bring people up to some minimum levels. When you think about legal education, it gets a little tricky. How many people in the room think that the passage of a bar exam is a good test of whether or not someone is or will be a good lawyer? Okay. Not a lot of, oh, there is, okay. One brave soul, okay. So I don't think there's many people who really believe that, and we'll have a conversation later. You can, because I could be wrong. But it seems to me we think it's wrong on both ways. That is, people flunk the bar exam, and we don't necessarily say that they won't make good lawyers and they can take it again for a certain number of times. And some fairly famous people have flunked the bar exam at least the first time and have turned out to be reasonably good lawyers or even excellent lawyers. And on the other side, of course, if there are any bad lawyers, presumably they all pass the bar. So it doesn't work either way. And we don't really have any sort of mechanism like that to decide things. And so, you could think about this in a variety of ways. We have tried at our clinical program here at the law school to have ourselves separated by a breezeway with an airlock and two doors from the rest of the law school. But nevertheless, some vague marketed ideas have come across. So we could just think about, well, what's the problem? Plenty of students want to come to the University of Chicago. They're our customers. We have way more applicants, even though we keep raising the tuition. So on that level, we must be doing well. There's 180 to 200 accredited law school. I can't keep track. And we compete with all of them. And since we seem to be doing better than many of them, if not most of them, certainly we must be doing a great job, or students wouldn't come here. And you can say, well, connected to this, we would say, well, our students are highly sought after by law firms and other people who might want to hire them. And you can say that both as an absolute term and in comparison with other law schools. And I take it that the point about why students might come here would be perhaps connected to the fact that they're sought after when they graduate. So those are two market measures that show that, in fact, this is a wonderful law school. And plenty of individual clients want to hire our students, either through their law firms or if they're a small number of them who hang out a shingle by themselves. Everyone's happy. What's the problem? Everyone's happy. What's the problem? And I think the question that I would raise is whether or not this picking a lawyer, choosing a lawyer, deciding the quality of the lawyer has led to some regulation of the legal market. And I would suggest that the reason that we have regulation of the legal market, why after all have a bar exam, why have law schools accredited, Why have any of these measures? Why have an attorney registration and discipline commission that throws people out of the practice of law from time to time? Is because there is no easy way to judge the safety, let alone the quality of the practice of law in this country. So in my view, it is a little bit like why we have the Food and Drug Administration. You can't tell, most of us can't tell unless we're chemists, whether a drug is going to be safe, and it would require a huge investment of our time, and so we think the government might do this. And so I take it to some extent we think the government might do this through the regulation of who gets to be a lawyer and who gets thrown out. And to the extent to which that's not very good, as by the almost unanimous acceptance that the bar exam doesn't test this very well, and there, as far as I know, there is no other test, that perhaps we should at least think about other ways of thinking about the quality of lawyering. One of the things that I think we have to be a little bit embarrassed about is just to look at recent history, particularly in this state, but across the country, where we've had huge numbers of people who have been convicted of crimes and been exonerated, and many of them on death row. These are people who came very close to being executed. We don't know whether anyone who's innocent has been executed. And unfortunately, there's lots of reasons why these things can happen, but unfortunately, when you look at the cases and read the decisions in which the criminal defendant ultimately gets off, you often find that, in fact, it's because of bad lawyering, and bad lawyering in a variety of ways, in attention to detail and a variety of other things. So it seems to me we should at least be thinking about whether the quality of lawyering in this country is what it needs to be. And if we think of this as a profession and not just the production of widgets, then I think we may not be so sanguine about the actual ways in which people get to be lawyers, and whether or not the fact that our graduates make tons of money shows that we're doing a good job. It doesn't show we're doing a bad job, but it doesn't show we're doing a good job. So then it seems to me it might be useful to think about what kinds of pedagogies you'd want to engage in if you have these huge goals. And unfortunately, because the goals are so diffuse, we can't quite agree on this. But I do think that the Carnegie report and the work that is done in response to it can lead us in some useful directions of things that perhaps we do well. As Randy Picker showed, I think we do a lot of things quite well. I have no complaint about our ability to teach an understanding in a fairly sophisticated way of law and the interaction of law and economics, and many complicated arrangements that go into that. But we could think about what we don't even attempt to teach in ordinary academic courses, which I think is part of the reason why we may want to have other pedagogies other than the so-called signature pedagogy of law schools. And that's really why I think most clinical teachers, even though they may not have the same views about what the priorities are among the goals I suggested earlier, have seized upon, at least as one of their pedagogies, the idea that what we are teaching students, a goal of what we are teaching students is judgment. And the way you can learn judgment is to exercise judgment under supervision, so that while you get to make the judgment, the consequences will not be so severe if you make a mistake, if your judgment is off. And that is the signature pedagogy of clinical education, in my view. There are other pedagogies, and there's, among clinical teachers, lots of disputes about other ways in which to teach what we think we're teaching. But I think the signature pedagogy is that we make students do things that are very difficult, that they have never done before, when there are real consequences, and they understand that bad things can happen to the client if the judgments are wrong. And that's something that it's very difficult to teach in the classroom. So I'm maybe saying things that Professor Stuckey wouldn't like. But I'm not necessarily thrilled to think that we should impose upon our academic colleagues, whether it's Randy Picker or anyone else, that he has to have more of what I would call clinical methodology in his class. I think he's got plenty of stuff going on in his class, and I don't know what, where he would find the time. And it seems to me that the other thing that one thinks about when one is thinking about devising an entire law school curriculum, someone can be good at one thing and not another thing. And so I have no reason to think that Randy Picker wouldn't make an excellent clinical teacher, but on the other hand, he would need a lot of supervision, at least for the first few years.
5 years.
After that, I'm sure, at least I'm not that good of a clinical teacher, but my colleagues here could whip him into shape. And it seems to me so that we understand that across the curriculum. We have economists here, we have philosophers here. We don't make the philosophers do economics and vice versa. It would seem stupid to do that. Use your time effectively. So the other thing that I think is left out that is of a traditional curriculum, which we attempt to do in clinical education, is to begin students in the process of learning the human relationships as it relates to being a lawyer. So not just all human relationships, that's a task beyond anyone's ability to do, even in School of Psychiatry or Psychology, but to get to understand how to function in the role of a lawyer with clients. And that, I think, with all due respect, is scalable. That is, it is different to react to one individual client and Microsoft, but Microsoft is a corporation and it functions through human beings just like any other.
No human beings at all, it turns out.
Oh, okay. Well, maybe Microsoft wasn't the good example, but if we would take something out of the technology business, okay, like Dominic's Food Store. Okay, so they have human beings there. Okay, thank you. Just checking. So someone at the corporation has to hire you as a lawyer, and you have to manage that relationship, and that is something that lawyers need to learn how to do, manage relationships. They need to manage relationships with clients, with opposing lawyers, with courts, with legislators if they're doing that kind of work, with a whole host of other kinds of things. And the traditional law school curriculum doesn't have much of that. Now, I take it that, I agree with Randy Picker about another thing, several other things. One is that there are some distinctions between medical schools and law schools. I don't think quite as many as he suggests. In the sense that, so we expect at this law school that people will go to large law firms overwhelmingly, but not exclusively. And the theory about why we don't have to teach A, B, and C is that the law firm will teach A, B, and C, and that it's sort of like the residency. Part of the problem with that argument, there's several problems with it, is that we do not have separate specialties and licensure with some very small exceptions. So that if you graduate from an accredited law school and you pass the bar, you can do practically anything on day one as a matter of licensure. And that has got us into all kinds of problems. So if you look at what has happened in the death penalty area, we have had to create, in some states, we've done it here in Illinois because we had such a disaster, we had to create special licensure for people who are going to handle death penalty cases. I think that's a good move, but it's a reflection of the fact that we were making people do this work, or asking people to do this work, or paying people to do this work who had no experience in doing it and were not licensed, trained to do it. And it seems to me that law schools at least have to struggle with the profession, whether it's the American Bar Association or the ALS, and other groups, to think about how we can ensure that the bottom is competent to do what is necessary to do, that there are minimum standards. And so I don't think we can quite say, well, someone else is going to handle this training unless we can conspire with other organizations to make sure that, that minimum standards of quality are met. The other thing I think it might be useful for me to take issue with Professor Picker. So this is not the University of Chicago School of Policy. This is a law school. It's a professional school, as the medical school is, and as other schools are, journalism schools, et cetera, et cetera. So it doesn't seem to me that it's a particular criticism of a book that would be writing about legal education that would say, that has to be our priority. That if we don't turn out competent professionals, then we have no justification for being. We could, you could have here a graduate school which would study law. We could study law and economics. We could, and those are all useful things to do. But that's not what the university should, the basis for having a law school. The basis for having a law school is to train people, prepare people to be lawyers. And if we don't do that competently, we can't do anything else. You don't necessarily need to take the perhaps extreme position of Professor John, who's in the audience today, who says that if we have any research, it will hurt the profession. But you might take the position that that preparing people to practice law is more important than research, and that research should be serving that goal. And if it isn't serving that goal, then it should not be a priority for law schools. And we could go back to since this is our 50th anniversary, we could go back to one of the statements made by the founder of the Mandel Legal Aid Clinic, Ed Levy, or one of the founders. And one of the things that he suggested was a justification for having a law school clinic was that the academic faculty could study the law as practiced in the clinic. And I think if I have a critique of legal research is that it doesn't do that. It's not just that it doesn't study what's going on at the Edwin F. Mandel Legal Aid Clinic. It's that legal scholarship as a whole pays very little attention to the practice of law. They pay attention to a lot of other things, but they pay very little attention to the practice of law. And I think it therefore doesn't, it's one of the reasons why, if you say, yes, you should be doing research that's connected to your teaching, and that will help your teaching, it's one of the reasons why I think our teaching as law schools hasn't been as good as it should be. And that is because we have not had people who are teaching in our law schools who are focused on how we practice and how we can make better practitioners. And if law schools don't do that, it seems to me they should be closed up. End of story. And I don't think it's an accident that on your slide you put research first and teaching second. And I think that is why it's not just that we might not like the University of Idaho, or we might. It might be fulfilling a good market or it isn't. But I think it's the very top law schools who may be failing in their job to prepare people to exercise judgment and to interact with clients.
Thank you, Mark. I think what I'd like to do is offer, I thank you to all of our panelists. I think what I'd like to do is we have maybe 15 minutes left to offer 2 rebuttal periods or reply brief periods. First to Judith for a couple minutes, and then to Randy for a couple minutes, and then open up to questions.
Well, thank you. I found this very provocative and insightful. One thing I wanted to begin with is just clarifying issues about Carnegie and the mission and why certain things are addressed and other things aren't. I think Randy appreciated and noted that this is the Carnegie Foundation for the Advancement of Teaching. So the focus really was on teaching and learning. We did sit in not only on first-year classes, but on what other advanced classes we could, given that we were doing site visits of just 2.5 days. So I would say that what you demonstrated in your presentation to me is masterful teaching. And I would say in a lot of respects, what you display there is really hitting all the tones that I think that Carnegie was trying to bring forth, because you're conceptual, obviously. You're making visible your thinking in ways that students can relate to. You're really showing them where to go to gain insight. In a way, you're working with them as communities of practice insofar as you're having them do blog entries. They're obviously engaged with that because you are helping them. You're not throwing them to the wolves. You're building what they need to have, and you're branching in advanced ways beyond the very beginning kind of thing that typically comes up with the case dialogue method classically in the first year. So I would say that's wonderful. One of the things that I wish, and maybe you and others would think about this, I think one of the failings of legal education is what is being done creatively in different places is so invisible when it comes to teaching. I think the ALS has not been doing a good job in terms of really trying to find out the innovative things happening at schools and letting people be aware of what each other are doing. There's been a recent survey about what schools have done that is now available on the ALS website, but the kind of good work that individual faculty members are doing is not always visible to others. So wanted to speak to that. In terms of research, I agree that research is of cardinal importance to faculty, and I think particularly faculty members who've gone to schools like Chicago and who have multiple degrees and things of that sort and possibly more limited practice experience are living that every day. But I would have to say where some folks end up teaching is not the school they went to, and that as a result, much of what drives, in my opinion, what's happening on the ground is it's not just the abstract missions of schools, it's who's in the classroom. Who are the students, what do they have coming in, and how do we prepare them for a range of things that they may want to do later. I think for some of the very top schools, probably the students attending have at least 50% of the analytical capacity, if not more than that, as they come in the door. So I think sometimes what's going on in those settings inherently will be different from instances where there's a different mix of students and backgrounds and things of that sort. One of the things that really can advance learning in less elite schools, I'm convinced, is working with problem type teaching and learning, and I think that legal writing and clinical offerings and things like that often are able to reach students who might not be as readily adept at what others may do in settings like this by giving them a chance to see themselves in the picture and developing a range of complementary skills. Just maybe one more thing, in terms of the situation with medical education, I think we appreciate that medical education is different for lots of reasons. For one, students there are expected to complete a pre-med line of coursework before they ever get there, so they're starting in different place than we who take people from a variety of backgrounds coming in. They also have a different funding structure because of federal support. They have built-in learning laboratories, typically with, if they're affiliated with academic hospitals in one way or another, but nonetheless, I think that they really, in their students graduating, are taking them through different rotations in different fields where they're getting expertise. I think, would have to challenge a little bit about the body as unitary focus, because as I interact with colleagues in medical education, they're dealing with, all the different dimensions of science, all the social medicine, all the range of things that may enter into what doctors need to know, and they do have structured residencies, so they have a longer period of time in which to build upon. However, it's striking to me that they have a number of things that we don't. I think the assessment structure is much more advanced there. There's more writing about trying different educational approaches that then are evaluated and documented and critiqued. I think that they have made real strides in terms of how they assess graduates by using virtual patients, simulated patients when they're doing the equivalent of bar exam. That's a very expensive kind of proposition, but I think that there's a lot to be learned from medical education, even if it's not a one-on-one match.
Just switch on top if you want.
I don't really need it. I just want to say one thing, I guess, about what Mark said at the very end about my last slide, which is, he says, well, you know, obviously you put research above teaching. And I guess what I want to say is I put understanding first. And I can't teach it if I don't understand it. It's that simple. When I have bad days in class, it's because I haven't understood the stuff well enough. You know, that's what happens. And I guess for me, it's this powerful link between research and understanding and then teaching that drives it. So that's the sense in which I think, in some sense, learning comes first, and learning means understanding. And if you're talking about the most complex, interesting problems, the problems that our students are going to work on as lawyers, then I have to work really hard to understand them, and that means at least consuming research, but I suspect it also means producing research.
I'm not opposed to research.
Let me just ask the first question, just following up on that. And the question for the panel would be, are there other ways beyond research, as you seem to be understanding it, to generate that kind of immersion? Because it seems to me that perhaps immersion in the topic is what you're looking for, and that journal articles and research is one inroad into that. There may be other inroads too.
Yeah, I can talk about that. I'm not sure that's a popular answer. I'd say consulting, the truth. So, you know, I've been involved in the last year in the Google DoubleClick merger. That means I've met with, on behalf of the clients, as part of a team, the Federal Trade Commission twice, DG Comp in Brussels. Boy, I learn a lot. I think I can take that directly into the classroom. I think we've had issues with this in the past. I think professors doing too much consulting is actually not a good thing. So I think the right amount, I think 0 is the wrong amount, precisely for that immersion reason. But I think you can also, you know, let it dominate your life, because then you're not doing what you should be doing.
Let's open it up to questions.
My first question is, Professor Picker, do your students get your slides?
Yeah, so I blew through it a little bit. I actually have different pre-class slides and post-class slides. Now, they're not always different, but the basic difference is the pre-class slides have hypos without answers. Post-class slides have answers. So that's starkest in my secure transactions class. In secure transactions, as I tell them, I walk in on the first day, I say, this isn't con law, we have answers. So there are actually questions I will ask that have black and white answers. The statute will tell us we should get it right. There'll be hard questions, to be sure. That's where you're going to live. And so on those days, if you download the pre-class slides, it'll be a series of hypotheticals. I wrote the case book, so they actually track the case book. No answers. Slides go up after class, answers. So yes. And indeed, as you'll recognize very quickly, as soon as you start posting slides, the instant you don't post them, you'll hear from your students. So, yeah, absolutely. Yeah.
Actually, what? And then we'll do Gary. Yeah, go ahead.
You know, as I read the training report, and it was talking about shadow pedagogy, and I probably this is addressed to Professor Baker. I mean, what you say you're doing in your class sounds fabulous to me. You know, but the question, there's two questions. One is really what's left out of that kind of format. You know, what are the aspects of legal education that Mark was talking about, for example, that simply are not amenable to that? And the other that I think I disagree with a little bit is that to the extent that the sort of the case method large lecture format is the signature pedagogy of law schools, you know, the Carnegie report talks about the first year of law school, but then it basically says, and they keep doing it over and over and over again. And you know, at least at Wisconsin, our experience is the students sort of vote with their feet. They're out of there. They're tired of it after about a year and a half. And it's just, you know, one more subject matter, same format. So I don't know if you think that's a problem or not.
Yeah, I can talk about both of those. I will see 300 students this year. I have 135 in antitrust in the fall. I'm teaching network industries right now to 62. That's my small class for the year, almost certainly. And I'll be, I would think, between 70 and 100 in copyright in the spring. 300, it's not a good thing to be a 300 hitter. And we have colleagues occasionally who hit the mythical 400. So I don't know what to say about that. I mean, you know, I do a lot of, I think, development of ideas, but I also do a lot of Socratic, and students can talk about that. Maybe there's nowhere else to go, and that's why they take my class. Okay, but I see a lot of students. On the point about what I can't do in class, I agree with Mark completely. And what Mark said is, we don't all have to be the same. We don't all have to do it in every part of the curriculum. I agree with that completely. So I think it's really important to figure out in what context we think certain things can be taught best and where they can, and try to maximize those. What I tried to say on the scaling point was, I think, modern antitrust practice might not be the place to do that, right? Other places may be much better for that. So I completely agree with Mark on that.
Gary?
Yeah, my question is, your course seems to be, this is for Randy, your course seems to be a litigation-oriented, antitrust litigation. And if I'm right about that, which you're not, how would you make it different if you were teaching students to be antitrust advisors and planners?
Yeah, good. So I think different courses, different things. So my secure transactions class, I think, is very much a class about what I think I teach them in that class is deal structuring. That's what secure transactions lawyers do. Sure, you see cases, and we'll look at cases, but the truth of the matter is, in my case book, you could probably rip the cases out and just do the problems. And the joy of the setup of it is the problems sort of, take fact by fact, and at the end of 4 problems, then you're at the richness of the case, and you read the case and see the result. But that class is very much a deal structuring class, where Judith's point, mastering uncertainty, that's really what the transaction lawyer has to do. How do you design a deal to recognize that there's enormous amounts of uncertainty? The students want to say, figure it out. No, you have to figure out how to design around it. So I think a deal class, which is what secure transactions is, it's very different than a class like antitrust, where I think it is first and foremost we do some business advice stuff. So I don't know. There's a business review process actually, and they publish letters, and we look at some of those letters. So the whole DVD structure is based upon some letters between Sullivan and Cromwell and the Department of Justice. We actually teach those in my network industries class.
I'm just trying to point out the question.
Oh, who are you pointing to? Oh, yes, go ahead.
I have an observation more than a question, and that is something that I think is chronically a problem in teaching. And it's not just here, it's I've witnessed it, for example, in the physics colloquium here at the university routinely, and that is the inordinate use of these visuals. I was quite struck here today when you were saying a lot of interesting things, that you're standing over here looking at the thing. Everybody's looking up there. Nobody's looking at you. That's a very strange way to be teaching.
I'm not that attractive a man, I'm sorry, but...
Do you think there's a problem with that?
Yeah, good.
I mean, but it is. It's moved the television relationship into the classroom.
I'll say I think of you as a monosensor. And what I mean by that is a monosensor. You think it all comes in through one sense, right? I hope what's going on in my classroom is that we're both getting audio and visual at the same time, right? I think of most of my colleagues as being monosensors. They operate on one sense all the time. I think if we actually look at learning research, right, that learning research suggests that people have 2 senses, right? If they could taste me, maybe we should go there. Exactly. That's what we should head for. But I can probably only operate on 2 at one time. And so that is what I think I'm doing. This room has issues. That's why I stand where I do. Let's go to a different room, but that's a different discussion, and the dean's not here. But so we can talk about that a little bit. But boy, you want to put up statutory text. You want to do careful analysis of text. I participated in the redrafting of Article 9. We wrote one section that you can't read it unless you already understand it. Okay, but I can talk you through it. But boy, if I can put that language up and I can put words in different colors, I can do, I think, a really good job of doing that. I think for deal structures, Gary asked about a deals course. I think for doing deal structures, I did these kinds of pictures when I practiced. I just didn't have the right tools. I think they're brilliant for doing that. For putting up complicated economics, really good at that. For setting out pretty simple hypotheticals, really good at that. So I put pressure on the monosensors to define why they just want to talk. You certainly don't want me to write on the board. I'm terrible at that. This is vastly more efficient, plus Herschella's question, they get to download it all, so they can have it. My students take notes on those slides in class.
Well, let me just add one comment, and that is, I think the most remarkable thing about this sort of thing is that people sit and take it. That they, you know, I mean, it really is a very strange.
I'm going to see 300 students this year.
Everybody is, including the speaker, everybody's looking at the screen. Don't you find that very odd? I don't know what this monocentricism is. That to me is a very strange way of relating to one another and learning. But anyway, that's maybe I just being.
We're almost out of time.
We have one last question, sir.
I was really impressed with the way Randy integrates his research into his teaching. I wonder how typical that is. When I see the research coming out of the elite law schools, it seems far removed from the elements of practice, the doctrinal elements that I think students need to have before they graduate. I think it'd be a great empirical study to look at the research coming out and compare it with what we think students need to learn. And I think aggravating that is the fact that at the elite law schools, the bulk of hiring now is the PhDs who have no reservoir of practice, almost no reservoir of practice to draw upon, which wasn't true years ago when I started, 40 years ago.
I think we struggle with that, and I think different schools approach that differently, and I think we struggle with that. On the research point, you know, I'm a big believer in research portfolios, so you can pull out some of my papers that look like they have nothing to do with practicing law, and they probably don't. But I also, and I think it's important to do deep research that'll pay off in 20 years if all goes well. It's also important to have in your research portfolio things that are much more about the issues of the day. I think it's one of the great things about being in a law school, that I love about being in a law school. So I try to do both of those. I'm sure other people run the portfolio differently.
Well, looking at your own colleagues, how would you think they measure up on your own?
We want names.
My colleagues are the best, you know, I love my colleagues. And I think we care about law here more than any other elite law school.
Thanks to all of you. Thanks to our panelists.